Good morning, friends. I am again before you with topic. This is my third topic on power of attorney. Sometimes what happens, the person comes with a revision petition before the Honorable High Court, and High Court knows and see the documents that this person is actual one, unnecessarily wasting the time. So rather than getting relief, he may be put to costs, legal costs. So this is the same case I am discussing. This is case is Ved Prakash Gupta versus Lilu Ram Jangra and another that was decided on 4th April 2002. And our Honorable Justice M. Kumar were the judgment writer and author of this case. So this is a revision petition directed against the order dated 2nd March 2002, passed by Civil Judge, Junior Division, Hisar, dismissing the application of the defendant petitioner for recalling Devi Lal, PW1 clerk, who was examined to prove the general power of attorney. The Civil Judge has also imposed costs of Rs 300 while dismissing the application. Now coming to the brief facts of the case, the plaintiff respondent filed a civil suit number 572 of 1997 on 25th October 1997 for declaration to the effect that he is transferee allotee of plot number 1207 sector 14 Hisar. He further asserted that he is entitled to get his name entered in the official record of Udda. He further claimed that he was entitled to make formal transfer as he had purchased the plot in question from the defendant petitioner through general power of attorney, executed in favor of Ajgar Sen. In the written statement filed by the defendant petitioner, the stand taken is that he never executed the general power of attorney dated 14th November 1990, nor it was signed by the defendant petitioner. It was also denied that he ever appeared before the registrar for the registration of general power of attorney relied upon by the plaintiff respondent. He alleged that the so-called power of attorney is fabricated and forged document. After the evidence of the parties had been concluded and the case was fixed for rebuttal evidence and arguments and application for recalling Devilal, PW was made, which was dismissed, and order dismissing the same is the subject matter of challenge in this revision petition, which is as under. The applicant has leveled serious allegations in the application that court did not grant any opportunity to the applicant to cross-examine the witness. The perusal of the record of the case file reveal that the allegations of the applicant are absolutely false, malified, and useless. Only to delay the proceeding of the case, it appears that the applicant has filed this false application. A perusal of the order sheet reveals that witnesses were recorded on 6th January 1999. The presence of the counsel is well marked by the court on that date. It is the case of the applicant that Shri C.P. Likha was his counsel on that day. The record reveals that P.W. Devilal and Ram Bhakt were examined on that date. Both the witnesses were cross-examined on that date. In the cross-examination of PW1 Devilal, the name of Shri C.P. Likha is missing, but it is well mentioned in the cross-examination of PWT Ram Bhakt. What missing the name of Shri C.P. Likha in the statement of PW1 appears to be clerical mistake. It is not possible that if the two witnesses are examined on one date. Out of them, one may be cross-examined and other may not be cross-examined. It is clear that the counsel of the applicant was well present in the court as he cross-examined PWT Rambhakt, and the presence of the counsel has been marked in the sheet. It is not the case of the applicant that on that day his counsel cross-examined only one witness and he forgot to examine the other witness, or the court did not allow him to examine the other witness. The case of the applicant is only that PW1 Devilal clerk was not examined in the presence of his counsel. As the presence of counsel is well established from the record thereof, it appears that the applicant has given a totally false version. Had his counsel not present in the court on that date, then he must have been proceeded ex parte by the court. If the name of the counsel of the applicant could not be written in the cross-examination, that does not mean that his counsel was not present in the court, as his name is well mentioned in the cross-examination of other witnesses and in the order sheet. Presence of counsel is also marked. The applicant is habitual of filing such type of application only to delay the proceeding of the case. The conduct of the applicant is very much clear from the record. Previously also, the appellant has filed such a type of false application. The sufficient opportunities were given to the defendant to conclude his evidence, but he failed to conclude his evidence. Therefore, the evidence of the defendant number 2 was closed on 10th May 2000 by the then Learned Civil Judge Junior Division Hisar, by detailed order dated 10th May 2002. The case was fixed for rebuttal evidence and arguments, but with an intention to delay the proceeding, the applicant filed an application for amendment of written statement. Anyhow, in the interest of justice, application was allowed by the court, subject to payment of ₹1,000. After that, the applicant defendant got examined 3 witnesses, namely Ved Prakash, Ram Bhakt, and Puran Singh Davda. The case was again fixed for rebuttal evidence and arguments. At this stage, the applicant filed this false application only to delay the proceedings of the case. The intention of the applicant are very clearly established, as no affidavit has been filed with the application. It will always be presumed that while recording the evidence, presiding officer will always give an opportunity to cross-examine the witness. If any party alleges that no opportunity was given, the allegation must be supported by with very strong reason and with strong evidence if possible. The authority of a presiding officer cannot be put at stake by writing 2 lines in the application that no opportunity to cross-examine the witness was given, and that application is not supported even by affidavit. Otherwise, also marking the documents as exhibit can be well agitated by the applicant at the time of argument. The witness need not be recalled only on the ground that some documents have been tendered by the witness and other party wants to raise the objection on the documents. If such practice is allowed by the court, there will be no end of litigation and such a type of application can be filed again and again. Resultantly, the application is liable to be dismissed with costs. So, going further, what our Honorable Court says, I have heard Mr. Vinod Gupta, advocate, learned counsel for the defendant petitioner, who has assailed the order dated 2nd March 2002 by arguing that the clerk from the office of Hooda is not a competent authority to prove the general power of attorney in favor of one party or the other. Therefore, it is necessary to call the clerk Devilal for further cross-examination. He has further submitted that the observation of civil judge that the application has been filed in order to delay the proceedings are unwarranted. Another argument advanced by the learned counsel is that the interlocutory order quoted by the civil judge shows that the counsel for the defendant petitioner, Shri C.P. Likha, was not present when PW1 Devilal was examined. Substanting his argument, he has pointed out that name of Sri C.P. Likha, counsel, who has represented the defendant petitioner, has been mentioned in the cross-examination of PWT Shri Ram Bhakt. Although Devilal and Ram Bhakt PW1, PW2 respectively were examined on the same day. Having considered the argument of the learned counsel for the petitioner and perusing the order, I am of the considered opinion that dependent petitioner cannot be permitted to recall PW1 Devilal because there was ample opportunity with the dependent petitioner to cross-examine Devilal PW1. It is not believable that dependent petitioner or his counsel was not present when PW1 Devilal was examined in chief. Yet he was present at the time of PWT Ram Bhakt was cross-examined in chief, who admittedly has been cross-examined by Sri C.P. Likha on the same day. The argument of the learned counsel that PW1 Devilal is not competent witness to prove the general power of attorney executed in favor of one Agarsen cannot be examined at this stage because such an argument is considered at the time of decision of the suit. It is sad to note that the defendant petitioner has the audacity of leveling allegations against the court for not providing adequate opportunity for cross-examination of PW1 Devilal. Such a conduct could not meet the approval of any judicial form. The civil judge has also concluded that on an earlier occasion, when the case was fixed for rebuttal of evidence and arguments, then an application for amendment of written statement was filed by defendant petitioner, which was allowed subject to payment of rupee 1,000 as costs. After examining three witnesses, the case was again fixed for rebuttal evidence and arguments. This application has again been filed to delay the proceeding. The conclusion reached by the civil judge and his observation that the application has been filed to delay the proceedings are not at all unwarranted. In fact, the observations are fully supported by the past conduct of the defendant petitioner. Therefore, the revision petition is liable to be dismissed with costs. For the reason recorded of this revision petition failed and is dismissed with costs of rupees 2,000. Cost to be deposited to the Haryana Legal Service Authority, Chandigarh by 20th May 2002. A copy of this order was sent to the office of the Secretary of Haryana Legal Aid Service Authority, Chandigarh, who shall inform this court as to whether the cost has been deposited or not. This is all about this case. So one should go for revision with a clean hand, otherwise the result will be as above. Thank you for watching. God bless you all. Thank you. Meet you again.